Good afternoon. This is Jennifer Carroll. Welcome to another edition of Florida Appeals Journal. Today we're going to talk about stay motions. And I decided to have this as an issue to address because everyone always gets confused about it, whether it's, trial judges, litigants. And I thought, let's try to make it simple and at least know some basic rules regarding trying to obtain a stay while your case is on appeal. So you have a judgment. It could be a money judgment. It could be a contempt order. It all depends the nature of the order. That's what's going to determine the best way to seek a stay. The basic rule you have to be aware of is Florida Rule of Appellate Procedure 9.310, and you have an A and B. And the A part is really moving for a stay, and we'll review that. But that's what gives the trial court the authority, and plus the discretion, but certainly the authority to grant a stay under certain conditions. It doesn't have to be a bond. A lot of people think you got to post a bond, but you don't at all, what you're able to do. And then you have B, which talks about an automatic stay you'll receive if the judgment or the order is solely for the payment of money. It can't just be for the payment of money and then other things. It's got to be solely for the payment of money. And there are certain rules requiring that and certain requirements. So A is 9.310A, stay pending review. Application of the Lower Tribunal. A party seeking to stay a final or non-final order pending review first shall file a motion in the Lower Tribunal, which shall have continuing jurisdiction in its discretion to grant, modify, or deny such relief. A stay pending review may be conditioned on the posting of a good and sufficient bond, comma, other conditions, comma, or both. So that gives the trial court a lot of discretion to weigh the different circumstances, the facts of a case, particular case, and determining what is the right thing to do. And now, the B part of the rule, there's exceptions, and that's you have a lot of exceptions, but number one is money judgments or money judgments. If the order is a judgment solely for the payment of money, a party may obtain an automatic stay of execution pending review without the necessity of a motion or order, so you don't have to go to the trial court, by posting a good and sufficient bond equal to the principal amount of the judgment plus twice the statutory rate of interest on judgments on the total amount on which the party has an obligation to pay interest. And then multiple parties having common liability can file a single bond satisfying the above criteria. Now that's if you don't want any discretion by the trial judge, and you've got a judgment just for the payment of money, you can post a bond. So you go to a bonding company, surety company, and see if you can get a bond, and they'll post a bond, but it's not the easiest thing. You still have to provide collateral, and most of these bonding companies aren't using real estate as collateral. You normally have to have money in the bank, a letter of credit from a bank to support it. That's generally how it works. So for you to try to get a bond. Now, you don't have to go that route. Some people think, oh, well, if it's a judgment solely for the payment of money, then you've got to post a bond and follow 9.310B1. But no, you don't. That's only, you can elect that. You can, and you may not even be able to qualify, right, with a surety to get a bond. So you can go under 9.310A, which gives the trial court authority to grant a bond and impose conditions. I mean, the judge is going to want to do everything he can to make sure that payment is secure of the judgment, and there may be ways to do that. There are ways to do it depending on the facts of each individual case. So that's very important because a lot of people just really get confused on that. Now, there is an exception even to the money judgment exception of 9.310B, and that's section 45.045, and that provides an exception to the supersedeas bond requirement. Quote, and that's subsection 2. In any civil action brought under any legal theory, A party seeking a stay of execution of a judgment pending review of any amount may move the court to reduce the amount of a supersedeas bond required to obtain such a stay. The court, in the interest of justice and for good cause shown, may reduce the supersedeas bond or may set other conditions for a stay with or without a bond. To me, that's a very powerful statute because you can have some situations where you can't afford to post a full bond. So let's examine what other things that a court can do to try to be fair to everybody, right? So that's actually really good. And I'm going to cite a case to you, Capital Development Group versus Buena Vista Terminal, 306 Southern 3rd, 342 at 345. That's a 3rd DCA 2020. And it states that the court has discretion to enter a stay under such conditions as determined by the facts of really your particular case. So very important. Those are very important authorities that will help with a motion for stay and trying to obtain a stay in the trial court. And let me just make this clear too. You always have to go first to the trial court with a motion for stay. A lot of times you think you can do your motion for stay in the first instance with the appellate court. And there is authority for it, as an extraordinary writs, under extraordinary writs power, you should be able to do that. But for practical, the way it really works is courts aren't going to get caught up in that abstract nonsense, right? They want you to go to the trial court first and ask for a stay. And then you can do what's called a motion for review. And I believe that's under 310F, motion for review of a stay order. And then the appellate court will review the stay order. Again, send your transcript up, put your evidence in there. And the court will see if the trial judge abused his discretion. Motions for stay are very, very tough. And here's why. What's the legal standard? Even that's not really clear, right? That's kind of this amorphous mystery that's floating around. What is the standard really to be applied? We know we got the rules, right? Okay, so then you try to look at the case law. So you try to look at the case law, in the various districts. So basically, and I'll cite some cases, but you have to show you have first a likelihood of success on appeal, right? Okay, so understand this. You're trying to convince the trial judge, who you may disagree with, a ruling that, hey, you're going to get reversed. I'm going to get you reversed. Not a good position to be in, right? But, judges, they're going to be professional. And if they can see, I think that you have a meritorious appeal, I think you could be okay under that ground. But it's still a very difficult position to be in, no question about it. And number two, you've got to show a likelihood of harm absent the entry of a stay. And what does that mean? I've seen some people try to argue it has to be irreparable harm, the type of irreparable harm, when you're going for a temporary injunction. But really, most of the cases just talk in terms of likelihood of harm. So you have to describe, well, how are you going to be harmed here if you don't get the stay? And that's got to be proven. That's very important. And a lot of the cases don't put this as a third element, but it's a very important factor. How's the other side going to be prejudiced? So if you're in a situation, well, wait a minute, you don't need the money. You're not going to be prejudiced. I'm going to be prejudiced if I don't get this stay. Then that's the standard. And that can be very compelling as long as you've got the right arguments and the right set of facts for that. So I want to cite a couple of cases. The Sunbeam television case, that's a 117 Southern 3rd 772. That's a 3rd DCA 2012. And then the Planned Parenthood of Greater Orlando, 148 Southern 3rd 810. That's a 5th DCA 2014. And that those are good cases to have to at least lay out the standard for you. And there was one case I wanted to bring to your attention, and let me see if I have that. It's the Silver Beach case. But there's good language in that. Here we go. Yes, Silver Beach. Now, that's the first district case. And I don't know if that's anyway, let me give you the site on that. 231 Southern 3rd, 494. And that's a first DCA 2017 case. I like that case. I'm going to tell you why. That stands for the proposition that 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 rule I told you about with the automatic stay provision for execution of money judgments. And what that makes clear is that rule doesn't eliminate a party's ability to pursue a stay under that separate section 9.310A that requires a motion in the trial court in an order. But that 9.310B is really, it only applies where you elect to utilize it. So it's not required, but a lot of people will try to argue that. So you want to be aware of this case. I think that shuts that argument down. And another reason why that case is good, it also holds a trial court has the authority upon a motion of a party under 9.310A to enter a stay of execution of judgment upon conditions other than a bond. I don't know how many times people have argued that, no, you got to post a bond, you got to post a bond. No, you don't. Okay. I mean, great. If you have all this money and you can do it, satisfy the requirements of a surety company, that's great. But not everybody can do that. And it may not even be appropriate. There may be, depending on the facts of the case, there are conditions that are going to basically protect everybody. So that rule and the case law with it support you on that. So I recommend, you review those kind of cases. Remember, you got to, no matter what, file the motion for stay in the trial court first, and then you can do a motion for review. And you can also, just call it a motion for stay also, if you just call it a motion for stay in the appellate court, but you have satisfied the condition precedent. You sought the stay in the first instance. And the appellate court, I mean, you may have a really strong appeal, and the appellate court will say, you know what, this is a really strong appeal. We really want to take it. And then you may get your stay granted. But just remember, definitely an uphill climb, uphill battle to get it. They aren't granted every day. So you have to have a very compelling case to warrant it. So that is, I think, the basic law. Just a very short, brief session on motions for stay. As usual, any questions, let us know. We're more than happy to answer them. Thank you again for your time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.